technology partner, Credit to Be. I'm Justin Warden, the marketing coordinator for Credit to Be, and I'm here with Ken Frisco, who's the operating board director for the Federation of Credit, and Joe Coleman of Kane, Russell, Coleman, and Logan, who will be presenting today on contract evaluation and selling to potentially troubled customers. A few things to get out of the way before we begin. If you do have any questions throughout the course of the presentation, you can feel free to use the question or chat function on the side panel and pose the questions there. I'll take all those questions and save them for a Q&A at the end of the presentation. If you're looking for a copy of the presentation slides, they're available in the handout section for you to open and follow along with during the presentation. And that's also found on your side panel. The last thing is we have a brief survey that will pop up as you exit the webinar. It takes about 30 seconds to fill out, but it gives us a lot of great insight into how we can continue to improve our presentations. So with that, I'm going to pass it over to Ken and let him introduce Joe.
Okay, thank you, Justin. Good afternoon or good morning, everybody, depending on where you are in the country. I'd just like to give you a brief background about Joe Coleman's background. He is the founding director of the firm that Justin mentioned and chairs the Insolvency, Bankruptcy, and Creditors' Rights section, which focuses on corporate and business reorganization and debt restructuring work throughout the nation. He has substantial experience representing unsecured creditors committees, lenders, debtors, equity holders, suppliers, trade associations, financial institutions, real estate companies, trustees, and examiners in a wide array of pre-bankruptcy workouts and restructurings, reorganization proceedings, assignments for the benefit of creditors, adversary proceedings, foreclosures, and virtually all aspects of bankruptcy and insolvency issues and related litigation. Mr. Coleman has represented 38 creditor committees in 16 states and confirmed in excess of 12 plans of reorganization representing both public and private debtors. Recent honors, he's been ranked by the Chambers USA America's leading lawyers for businesses as being among the top bankruptcy lawyers in the United States 2010 to 2015, and is being named by peers among the best bankruptcy lawyers in America, listed in the best lawyers of America. So I'd like to now turn it over to Joe to begin the presentation.
Thank you very much, Ken. This is Joe Coleman. It's a pleasure to be here. I appreciate everyone listening to that long introduction. Man, it's about me, and it almost it kind of bored me, so I can imagine you guys. Let's get right into the presentation. You know, my theme here, more than anything else, is trying to help credit professionals add value to their company. Hang on a second, I've got a technical difficulty because my screen is not moving. So let me finish the introduction, and I'll work on that.
Hey Joe, if you click on the slide, it should work.
Okay.
On the screen and then go.
Say it again.
Click on the actual screen and then you could start using your clicker.
Fantastic. Okay. So the theme here is helping credit professionals add value. And you guys know your job and what you do day in and day out. But some of my thoughts are, as far as helping credit professionals add value, is, for example, contracts. No doubt tons of contracts cross your desk throughout the year, but wouldn't it be nice if you had a checklist or you had something to look at, so when you're looking at a contract or even POs and invoices, and you had a checklist so you could spend a few minutes and say, you know, does my company have this provision? You know, have we eliminated consequential damages? So if we get sued, we save millions and millions of dollars. You know, nothing that will take a lot of your time, but try to fortify you to add value as you look at contracts. Number two is every credit professional has a sales guy that calls and says, I got this great sale. Yeah, I know that they're having trouble, and I know we've had problems in the past, we cut them off, but we need to sell them again. And perhaps there's instances where you want to at least investigate selling a troubled customer. Well, we only get so far in our career saying no, no, no. How about at least looking at some alternatives for maybe selling a marginal customer so you can be proactive and, protect the company while, perhaps accomplishing sales. So those are the two items that we're going to be talking about. And again, both themes are trying to help credit professionals add value. Number one, looking at the contracts. Where do our various sale terms come from? A variety of places. We'll hear from a salesperson, yeah, I played golf with so-and-so, this customer, and here's what we're going to do. Sometimes you have a complete negotiated contract. Often, you'll have your credit application, POs, and invoices. By the way, if your PO, of your invoice and your customer's PO conflict, who wins? So what are the sale terms? If for one particular customer, a delivery date, for example, is very critical, but all your other customers, hundreds of other customers, delivery date doesn't matter, and you really don't have a delivery date in your normal invoices, or the purchase order may not have a delivery date. What is the delivery date in the contract? Well, the Uniform Commercial Code will, if you don't have one, will put one in for you. And it'll generally be a reasonable delivery date. Well, what's that? So that's an example of having a checklist of things we can look at as various contracts cross our desk, and maybe we can add value. Okay, so you're doing business with a variety of customers, and generally speaking, as long as you make the sale, as long as the sale's happening, you've done your due diligence, your underwriting, away you go. Why do you care about the terms of the sale? And again, I think that's a chance for you to add value. Revenue is very important, obviously, and your contracts are very important, but knowing what the terms are. I've had a chance to talk to, roomfuls of credit professionals, and I'll ask questions like, raise your hand if you know exactly what the warranties are applicable to your product. Raise your hand if you've cut off consequential damages. Raise your hand if, in a collection action, you've prevented them from going to a jury trial, or you've enabled your company to have the lawsuit in your hometown. And virtually, many people just don't know the answers to those questions. That's what we're going to try to talk about here. So some of the provisions on this checklist. Who are the parties? You'll be amazed how many times I've had a lawsuit, a collection action, an arbitration, something, and we've done business with the wrong party. And it's very, very significant in certain contexts we'll talk about. Cost shifting, risk of loss. It's a great opportunity. Maybe you've been negotiating, or your salesperson been negotiating price. Maybe you've been negotiating the amount of credit you're going to extend the terms of credit. And it's an important customer, and we just didn't get our way. Well, there's another bite at the apple, so to speak. Maybe you can require them to pay all transportation, all insurance, and a variety of other cost-shifting devices. Arbitration's pretty popular these days. What does that mean, and is that good for you or not? Warranty and waivers of warranties. I'm here to tell you, everyone should have a waiver of warranty. There's no reason not to. On the back of your invoice, in your credit application, or in a contract that you have with a customer. Similarly, waiver of consequential damages, very important, we'll talk about. So we'll talk about the items on the left in some detail, and then I'll quickly go through the items on the right. So with that said, let's get started. The parties. Exactly who are you doing business with? Is your customer, and exactly what is their name? And are you actually doing business with the person on your invoice, or is that or entity on the invoice, or is that an affiliate? Do we know? Are they a foreign company? If it's a foreign company, then we have this United Nations Convention on contracts for international sale of goods. It's a mouthful, but that says, if you're doing business with someone in Spain, the UCC doesn't count. The Uniform Commercial Code doesn't count. We have this law, unless you express, by this law I mean the United Nations Convention on Contracts for the International Sale of Goods, again a mouthful, that will apply. So who the parties are and the exact name, they're important. And I'll talk about this a little more later. As I mentioned, cost shifting, risk of loss. There's a lot of items we can require our customer to pay: taxes, customs, duties, inspection costs, storage, insurance, freight. Here's an example of a provision, very easily inserted into a contract. Sometimes when I can't get what I want in negotiating head-on, there's another way to get another bite at the apple. Risk of loss. Is it clear? Again, we have the battle of forms: invoice, purchase order. Is it clear if the train derails or the truck gets in an accident, who has a risk of loss? We want that to be clear. Again, here's an example of a provision. Disputes. Happens to be one of my favorite areas for obvious reasons. And I think there's a lot we can do on the front side of a transaction to ameliorate the problems with disputes. Okay, first of all, we can mediate disputes. We can go to arbitration, good old-fashioned litigation. And I'll just tell you, as I get fatter and grayer, I've been practicing law for 30 years, good old-fashioned litigation doesn't work that well. And by that I mean not that you won't get your money, not that you won't, not that you're not right and you're entitled to justice, and it's probably the best system anywhere in the world. But with all that said, it's expensive as can be. It drags on forever. And one more problem. Let's say, for example, you have a $750,000 debt, delinquent debt. Your customer doesn't cure it. So fine, I hire my lawyers and I'm deposing my customer's principals, and we're all over it. And 2 years after the demand letter, we go to trial and we have a jury trial and we kick their butt and we win. And we have a jury verdict in your favor, $750,000 plus $200,000 for hanging out with your lawyer in legal fees. So you have $950,000, and the very next day they file bankruptcy. Who's better off? A creditor with an undisputed invoice for $950,000, or you with a judgment, a jury verdict for $950,000? At that point in time, you're exactly the same. You're an unsecured creditor. So the litigation, if we're going to go forward with the collection action, let's think about it a little bit on the front side. Mediation versus arbitration. What is mediation? Mediation is non-binding. Some independent party sits in a room and goes back and forth between you and the party with whom you have a dispute and tries to facilitate a deal. It's not binding. It's just a forum for negotiation. Arbitration, on the other hand, and I've seen many contracts where it says if there's a dispute, it will be submitted to the American Arbitration Association. I'm currently in the middle of an arbitration. I have a brief due tomorrow, so I'll talk fast. But an arbitration substitutes an individual or three individuals for the judge. It's private. I mean, I tried my arbitration in a hotel, a breakout room or conference room. But other than that, well, we had witnesses, we have objections, we have exhibits, but it's private before an arbitrator. And the arbitrator is generally either a lawyer, or if you have a specific industry or type of case that requires some specialized knowledge, then you'll have one or three arbitrators hear that case. And I'll talk a little bit more about that in a second. But then there's waiver of jury trials. And the better your case, the less you want a jury. I saw some stat, and you can't quote me because it was many years ago, but something like 75% of jurors, and actually I think it's higher, make their decision on who should win at the end of opening arguments. They pick who they like better. That's before any of the evidence. You know, if I have a terrible case and I should lose, I want a jury because maybe they won't follow it. If I have a good case and I have a collection case or a warranty case or a commercial litigation case, I'm often concerned about juries. Well, in most states, I know in Texas where I am, we can put in a contract a waiver of jury trials. It'll be tried through the judge. So I have a more sophisticated trier of the facts to make my decision. And generally, if I think I have a good case, I prefer that. A little bit more about arbitration. Generally, it's faster. In the case that I have, from the time we filed it to the time we had trial, it was 12 months. Very good. And I say it's generally cheaper. You have to pay the arbitrator by the hour, generally a lawyer. So now we've added another layer of costs. I get that. But if we go to trial in 12 months, you know, in my case it was multi-millions of dollars, so it's a big case. If we go to trial in 12 months, it's just going to cost less. If a case goes on for 2.5 years, lawyers have this ability to find things to do throughout that time. Often more sophisticated arbitrator. Here's a big issue with arbitration, and I've got one corporate client who the general counsel doesn't like it for this reason. There's almost no way to appeal, so you're stuck. And generally, being stuck with whatever the arbitrator says helps settlement sometimes. Arbitration is private, so if you have some confidential issues, sometimes that's preferable, as opposed to being in a courtroom where anyone can walk in off the street and watch your trial. And there's some flexibility to schedules. The negatives to arbitration, again, you have no recourse. Generally, no appeals, as long as the arbitrator's done a decent job. If you have a smaller matter, I do think it's too expensive. There's a certain lack of transparency because it's private. My experience is sometimes the trials drag on. You know, we'll have 3 days of testimony, and all of a sudden the arbitrator says, well, I've got my own deposition tomorrow, and when can you guys meet? We're coordinating calendars more than we're trying cases. But that's just during the trial itself. Sometimes it's truncated. It says, I have down here, lack of complete discovery. What I mean by that is, since you're going to trial pretty quickly, you may not take as many depositions. You may not, you know, both sides may focus on what they really need. Again, that helps the cost. So generally, you know, I think arbitration is something you could bring up to your in-house counsel. Is that something as a company you think would be preferable? Okay, moving on. Warranties, warranty and merchantability, warranty fitness for a particular purpose. By merchantability, you're manufacturing or supplying a product. Does your product meet the normal trade and normal industry standard? And this gets deductions you may be fighting about, rejections, etc. Well, why wouldn't your invoice or your contract or your credit application or whatever it is you're using to get your sale terms, why wouldn't you waive all those warranties? I have a case where we're sending a certain type of product up to the northern regions, and it operates outside, so it's bitter cold. And the other side saying, I've got a good breach of warranty of fitness for a particular purpose case because my client, the supplier, has been in business for 20 years. You know what it takes to operate in the cold. You've sent stuff up to the cold before. The customer, I'm new at all this. And I relied upon you that you wouldn't have sold to me if it didn't work up here in the bitter cold. Well, I'm kind of offended by that. But if my client would have had what I just flashed on the screen, and this is pretty standard stuff, if I'm a manufacturer in particular, I want to have these implied warranties waived. I don't want to have to deal with that. If I have a collection action, I don't want to catch a counterclaim for breach of warranty that didn't work, or breach of merchantability or applied warranty for a particular purpose. And I sure don't want to catch a counterclaim for consequential damages. Let's talk about that. Again, no one should be doing business without a waiver of consequential damages. What are consequential damages? You sell a product, and say you sell $250,000 of product. Well, they take that product and put it in something your customer's manufacturing, and they sell it as defective to their customer, and their customer, that defect causes an explosion or something. So now we got millions and millions of dollars of damages. Well, you couldn't really foresee that your sale of a product would be put in another product and it will somehow explode. Keep me out of that. Now, another example is a company sold a radio transmitter to a radio station. Radio station sold a bunch of advertising. The radio transmitter didn't work. And so they sued for breach of contract. But they had a waiver of consequential damages. So that radio station suffered millions and millions of dollars of damages because their station couldn't play. They lost all their advertising. But there was a waiver of consequential damages. So the court ruled, you're right, the radio transmitter was defective. And that called a $300,000 radio transmitter. You don't have to pay for that. But as far as all your lost advertising, the consequential damages, the things that happened thereafter between the customer and their third party to a contract, that's consequential. You don't have to, you're not suffering those damages. So waiver of consequential damages, talk about adding value. If you don't have that in the contracts you're doing business under, that's a big deal. Okay, let's keep going. Liquidated damages, and I'm going to move a little bit faster here because characteristically, once I get talking, things last longer. A liquidated damage is simply, in your contracts, you can agree, hey, this is the maximum amount of damages we're going to have. No matter what happens, you and I agree $100,000 at the most. I represented a New York investment bank, and they had in their contract a liquidated damage that said, you can never sue me, and you never can get damages for more than I billed you. Well, think about that. A New York investment bank could give bad financial advice to board of directors. They complete a merger that was a disaster. They lose tens and hundreds of millions of dollars, and their services cost $100,000. Well, both parties agreed, because it was in the contract, the maximum damages, $100,000. Now, it's got to be, it can't be unconscionable, put it that way. Similarly, okay, governing law and venue. Again, I'm a fan of this. An example is I had a collection case for a North Carolina client, and we were trying to work it out, and I was talking to the customer was in California, and I got the most pompous, arrogant lawyer representing that customer, and I had to listen to him, and I had to hear about he knew every judge and campaigned for the judges, and you're never going to be able to sue us, you're never going to be able to collect. Well, the contract had a North Carolina law applies, and the parties agreed that any lawsuit would be in North Carolina. Well, what a great provision. We filed in North Carolina. And that blowhard was long gone. That gave my client a lot of leverage. Similarly, you may have things in your law, in your state's law, that are unique that could give you an advantage. So why not decide up front where you want a lawsuit? Okay, the Convention of International Sale of Goods. There's more than 80 countries that have signed, this is through the United Nations, more than 80 countries have signed up to be bound by this. United States is one of them. China's another. So all those folks doing business with China, or with customers in China, you may be subject to the Convention of International Sale of Goods. And if you don't want to be, you have to expressly say it in your contract. There's all the countries that are subject to the Convention of International Sale of Goods, and there will be a test. So I hope you got them all. Okay, real quickly, I'm going to go over some additional. This is the same checklist that you can now pull out if you have invoices, if you have a contract that crosses your desk, and just see, do we have waiver warranties? Do we have waiver consequential damages? What do we have? Okay, price. That should be pretty easy. If we don't have something about price, then the UCC will plug that in, called a gap filler. So you can have a contract, a meeting of the minds, that's fully enforceable without the price. That's a bit counterintuitive. Same thing with one of the payment due. Everybody on this call knows all about that. How about the quality good? We're back to the merchantability. I want a waiver of that. I have a case right now where there was no delivery stated. The other side is saying it cost us millions of dollars because you delivered it late. My client, who's a very fine, reputable business that would never do anything wrong, said, hey, I can't guarantee a delivery date because it all goes over the rails. I don't control the railroad. And once again, the Uniform Commercial Code will say, if you forget to put a delivery date in, we'll put one in for you. You know, a delivery date must be reasonable. FAS vessel. Who's heard of FAS vessel? Raise your hands. Seeing no hands, that's free alongside steamer, which means if you deliver your goods to the dock next to the ship, title passes then, risk of loss passes then. Okay, again, my point here is the more specificity, the more clarity of the terms that are all beneficial for you, that should be in. The shipment, the delivery, other performance. If not, you're going to get stuck with this amorphous reasonableness. What constitutes acceptance? I like to have in contracts, you get 3 days to inspect. If I don't hear anything from you, we agree that you've accepted it. Once your customers accepted the goods, in order for them to claim their defect or any other problems, they have to revoke the acceptance, and you've got a lot of leverage on them at that point. You know, I've got 2 examples here. The last 2 lines says, time limitations. Failure to reject goods within 3 business days after delivery shall constitute acceptance. So you have that in the boilerplate of your invoice. You have in your credit application that the customer agrees that if there's any conflict between our invoice and your purchase order or bills of lading or any other writing, my invoice shall control. And they sign it and they agree to that. Well, now we have failure to reject goods within 3 days shall constitute acceptance, and they've agreed to that. They don't know they have, but they've agreed to that. Now when they're trying to do deductions and you know, 4 months later send something back saying, you know, it didn't work, you say A, well, you didn't notify us within 3 days, so you accepted it, and B, I don't want to hear about defects, we have a waiver of warranty. Now they may be a good customer, you may want to work with them, but at least you have some leverage. Force majeure, that means you don't have to perform because of acts of God, major strikes, hurricanes, etc. Indemnity clause, if you're a manufacturer, you may want to shift the loss or have your customer be responsible. Products liability, this happens a lot. You know, maybe part of your deal is, customer, we don't control what you do with our goods. If you get us sued because your goods blew up or caused an accident, you got to indemnify us. Just something to think about. Okay, what's in a name? This is a pet peeve of mine because I've been through innumerable cases involving name problems. Okay. you're doing business with Integrated Drilling. This is a real case, although names have been changed to protect the innocent. And you've been doing business with them for 10 years. And a client calls me and says, I've got a great big order for Integrated Drilling, and I'm really worried about it. I mean, they're a public company. They sell on the, they sell over the counter, but they have to file, and I've been looking at it, and they're a mess. I'm really concerned. They want $1 million of this purchase. My sales guys are doing cartwheels, but I'm really concerned because looking at their public filings, they're a mess. And so I'm greatly bothered by it. But the credit professional in that case is trying to be proactive, trying to say, I don't want to get in the way of sales, but for these 5 reasons I found in the public financial statements, I'm greatly concerned. So what I suggest we do is make the sale. We love our gross profit, but let's get a purchase money security interest. Let's get something to cover our downside. So we're negotiating purchase money security interest, and I ask a simple question of this public company's general counsel. The company we're selling is Integrated Drilling, LLC, correct? Well, yeah, that's what everyone's been saying. I said, I don't care what everyone's been saying. I want to know I've seen 20 entities on your public filing. What precise entity is getting my client's stuff? Where are the assets going? Because if I have Integrated Drilling, but they're really going to Integrated Marketing Drilling, and Integrated Marketing Drilling owns, has possession of my goods, I don't know that Integrated Drilling can grant me a security interest. And I don't know if I sue Integrated Drilling instead of Integrated Marketing Drilling, if I'm going to end up with a empty bag at the end of the day. I want to have the exact name. So we went to the Secretary of State. We figured out exactly what the correct name was. We got a rep and warranty. And then I made this in-house counsel. He didn't know. He did not know who was actually buying our $1 million. He couldn't figure it out. I said, you need to figure it out, and you need to satisfy us, which he eventually did. So we want to have the correct name for number 1, enforcement. I don't want to sue the wrong party. In our earlier example of $750,000 collection action, and we get our jury verdict for $750 plus $200 for legal, and it's against the wrong entity, I mean, that's a bad day. Similarly, with collection actions, I want to know where I'm selling it so I'm going after the correct entity that hopefully has the assets. Documentation, same way. And this is all kind of a segue to our second part of the presentation. If we do a purchase money security interest, as we did here, we have to be absolutely correct on our UCC1. And by absolutely correct, I mean we can't have a couple letters missing off our customer's name. So we need to have the precise correct name. Okay, just a couple last words on the contract, then we'll move on to purchase money security interest. So, I mean, you're doing business every day based on contractual understandings, but do you really know your terms, and how specific are they? When contracts come your way, I mean, maybe there's an important contract. Maybe you have a troubled customer. Pull out this checklist from today and see if you have a waiver of consequential damages. If there's a concern about a counterclaim in a collection action that your goods were defective, do you have a waiver of warranty? Again, this is all designed to help you add value to your company. You're not in charge, generally speaking, of all the legal terms in a contract, but the goal here is to help you to add value to the company. Okay, with that said, listen to me ramble on for 38 minutes. I kind of wouldn't wish on my worst enemy, so a little break. Okay, it doesn't exactly fit, but I just like it. I hope everybody heard that. Next, we're going to talk about purchase money security interest, jumping ahead of the bank. So I've been representing credit professionals for years, and my dad was a credit professional before that. And the idea of an unsecured supplier who always takes it in the shorts from the bank in bankruptcies because they have a lien, the idea that you get to jump ahead of them, that's something that I like to talk about. So we're going to talk about purchase money security interest. So your customer who you have some concerns about, and you look at the UCCs, and the bank has a lien on absolutely everything. And you have, you want to be part of this, you don't want to turn down every sale, but you have concerns. So maybe like this integrated drilling example, maybe we can do a purchase money. That gives you a security interest on the goods you are supplying. And it's accomplished by a security agreement between your customer and you, a notification letter to pre-existing lien holders, and filing a UCC-1 financing statement with the correct name. What I like about this, it allows you to have a lien on your goods that you supply, even though the bank has a pre-existing lien. And the Uniform Commercial Code 9103 gives you that. And is this fair to the bank? Not a question I usually care about, but I'll just raise it. The bank has a lien on the inventory, and the bank is, they're monitoring their lien. They're probably doing an advance rate based on inventory and AR, and the supplier is going to come in and take a new lien over and above them. Why does the law allow us to do that? Well, but for that purchase money, you're not selling in our scenario. But for the purchase money, someone may not be delivering a piece of equipment or inventory items. So the bank never would have had that as collateral. So the bank, in the way the Uniform Commercial Code looks at it, they're not losing anything. In fact, as you'll see, your PMSI, purchase money security interest, does not go to receivables resulting from your customer's sale of the goods. So the bank is actually getting a little bit. So it's a pretty good way of giving the supplier a shot at getting some collateral. How do we protect ourselves? How do we perfect? How do we do this PMSI stuff? Number one, if your customer has agreed to it, your management's agreed to it, first step, look at the Secretary of State in the state in which your customer is incorporated. They may do business, they may have their headquarters in California, but they are incorporated in Delaware, and we got to file in Delaware. Number two, conduct a UCC search, generally with the Secretary of State of that state, and you find out everyone and their grandmother who has a lien against your customer's inventory has a potential of a conflicting security interest. And we need to know all those people because we're going to now take a lien on a subset of your customer's inventory, namely what you sell them. Purchase money security interest means what the customer purchases from you. You can't take a purchase money security interest in what your competitor sells them. So you conduct a UCC search. Now I know everyone that has a lien on any of my customer's inventory. You put together a security agreement with your customer, and you give a written notification to all competing or potentially competing lien holders, generally the bank in our scenario. So that bank gets a notice. Be advised that we are perfecting a purchase money security interest on all of Acme bricks for sale. So it's fair to the bank. When the bank does their borrowing base and looks at the amount of inventory they have, they know they can't count Acme bricks. And we're going to give the notification before you ever ship. Before you ever ship. I mean, if you start shipping and you have $300,000 of inventory, and then you get around to giving a notification letter, you've defeated the purpose. That dog won't hunt, to use technical legal terms. So you send the notification before your shipment, you file a UCC before the delivery of goods, and then look at F. This is a step a lot of people skip, but I think it's imperative. Then you immediately do another UCC search. So you can see that your filed UCC1 is right there, right where you expect it to be. Because if you get a couple letters wrong in your customer's name, it won't show up. So let's be sure we did this right by doing a follow-up UCC search, and then make sure you file a continuation statement before 5 years. Did I say the notification before shipment? And did I say your UCC has to have the absolute, precise, correct name? Now, there are limitations. It's not the end-all and be-all. So I want to give you the downside. Again, you have to do your continuation statement within 5 years. When you file a continuation statement, so let's say you've been doing a PMSI and you've been rocking along for 4.5 years, you file a continuation statement, re-notice conflicting security interests. So you have to do another UCC search, and you have to notify everybody again. Be advised that you may say, I have a lien on all of Acme Bricks inventory sold to customer XYZ and all proceeds therefrom. So I should have a lien on receivables from my bricks. It doesn't work that way. You do not have a lien on the receivable that your customer generates from selling your goods. You only have a lien on your inventory. And if the inventory is sold by your customer in ordinary course of business, of course your lien goes away. Now you do have a lien on, in addition to the Acme Bricks, you get a lien on what's called identifiable cash proceeds. And as far as I'm concerned, you got a lien on nothing. There's no such thing as identifiable cash proceeds, because all the cash is going in a lockbox or all the cash is being commingled. That's very tough standard. So I wouldn't put any comfort in that. So a purchase money, you get a lien on the inventory you sold them and the inventory they have in their possession. So they're in default. What do we do with our PMSI? Step one, depending, it'll be spelled out in the security agreement, but step one is we make a demand. You owe us $350. You're late. The terms were 60 days. It's been 75 days. I'll give you 3 business days to cure default, or else we're going to exercise the rights and remedies. Meanwhile, I'm doing a lien search. I want to see who else. Now, the bank has a subordinate lien to you in your Acme Bricks, in your goods. I want to see if anybody else has a lien after the bank. All other lien holders I need to know. They don't cure, so now I do another demand letter saying the security agreement requires you to assemble all my collateral, namely all my Acme Bricks. You are to assemble those. We're going to come and take possession of them. If they don't cooperate and you go to try to take possession of your collateral, then you can't breach the peace. We can't have a little war here. And so in that case, you have to go file a lawsuit and do a judicial foreclosure. But if you can take possession of your collateral without breaching the peace, then you do a UCC foreclosure sale. Not overly difficult. You'll advertise it. You'll do whatever you can to try to get public notice. You hold an auction. I did this once for rolling stock, actually a bunch of trucks, and it was a contentious case, which seems to follow me around. And the customer videotaped me at the foreclosure sale when I read my foreclosure notice saying, well, we're taking bids on all these trucks. And I turned around, so my back was to the video camera, and the guy never followed me, so he never really got much. But you notify the other secured parties, in this case the bank, and you conduct what we call, you do some advertising, you conduct the sale, or alternatively, if you don't want to go through the public auction route, if you find someone to buy it, that's willing to pay good money, you can do a private sale, and the Uniform Commercial Code, the comments to it actually encourages that. So that's how you exercise your remedies. So again, my theme here is adding credit professionals adding value. So you have this troubled customer, but there's market share, and there's taking business from a competitor, and the salesman's a pain in the neck, and he's just beating you down, whatever reason, or your management wants to make the sale. So what kind of things can we think of to cover our company, or cover our downside? I heard about this PMSI, Joe, and we tried that, but when we sent the notification letter, the bank went berserk and threatened to put my customer in default, so that didn't work so well. What else can we do in addition to a PMSI so you can, A, protect your company, B, enable your company to make the sale at the same time, potentially, and C, add value? Well, consignment. We've talked about this through this federation before. A consignment is similar to a purchase money security interest. In fact, it's perfected exactly the same. But the difference is a consignment, you retain ownership to your Acme bricks. You retain ownership to the goods you sell. So you sell your goods, the goods are in possession of the customer, but you own them. And when the customer draws down one of your goods for the manufacturing process or for a resale, that's when the sale takes place. And you have a variety of rights, go in and look at the inventory and what have you, and then you have to file your UCC-1 to put the world on notice. Hey, bank, I know you have lien inventory. Understand, these Acme bricks are subject to a consignment agreement, so don't count that when you're doing your borrowing base and your advance rate. I mean, one place where a consignment would be different than a PMSI is you don't have to go through the foreclosure process we just discussed. They're your goods. If they're in default, you come pick them up. Another example would be your customer files bankruptcy. Well, if it's a consignment, and as they generally do nowadays, a lot of the bankruptcies are immediate sale of substantially all assets. And I am watching my time. I'll make sure I leave at least 5 minutes for Q&A. But so your customer files bankruptcy, and they file day one motion to sell substantial all assets under 363 of the Bankruptcy Code. Well, if you have a PMSI, that means you're a secured creditor. They sell your inventory, they sell your Acme bricks, and your lien attaches, and you fight with the bank about who's first attaches to the proceeds, the money. I have a case, right, a creditors committee in Atlanta, and we have that exact scenario where for the unsecured creditors committee, I'm fighting with actually four levels of debt, of secured debt, and we've gotten rid of two. We've got two more to go to get money to unsecured creditors, but they were able to sell everything. And then the secured creditors generally fight over the proceeds, who has a prior right. On our consignment, they can't sell your goods. They're your goods. Okay, bailment. This is one step more protection. I had a client who was selling a very troubled customer in Southern California, and because of the nature of the goods being sold, it was very convenient for my client to deliver goods to an independent warehouse very, very close to the customer. And so when the customer needed goods, and they gave them very short terms, they went from the independent warehouse to the customer. So when the customer filed bankruptcy, and they did, and it didn't surprise anybody, nobody had a claim to our goods. They were in an independent warehouse. In a bailee, the independent warehouse was the bailee. So he did it under a bailment, and that's not even quote-unquote property of the estate. Again, you do your purchase money security interest, and you do your notification, and the bank blows up and says, you know, I'll put you in default if you do this PMSI. And so your customer comes to you or you come to the customer, ever diligent in trying to preserve the sale, for all the reasons management's been talking about, and you say, you know, I notice on your balance sheet you have this raw land for future development. Is that encumbered? Well, as a matter of fact, it isn't. Well, instead of a PMSI, give me a lien on the raw land. Now, raw land is not always the best collateral, but it's another way to sell to a troubled customer if you can get a lien on something else that is currently unencumbered. A guarantee of the principal or an affiliate. Love guarantees. And if it's a principal, I try to get the principal and their spouse, because I love to have my collection agent basically sleeping with the guarantor. If I get a guarantee from both the principal and the spouse, that's a good thing. Or larger companies, you know, we've done our due diligence, we know the name, so we're going to sell to this affiliate, but this affiliate's kind of rocky on its own. You keep giving me these consolidated financial statements, and when I, you know, through my due diligence, I've seen the entity, the precise entity I'm selling, is not so stable or creditworthy. So I want a guarantee from the holding company. Letter of credit, great if you can get it. Develop an executory contract. So I'm in a workout situation, and we're selling back and forth, and they need my stuff, and they're very troubled. So we put together an executory contract, which is defined as, at the time they file bankruptcy, there's material obligations on both sides. You sell, they agree to certain marketing, to do certain marketing things that benefits your brand, and so both sides have material obligations. And they file bankruptcy. If they need you and they want to assume the executory contract, I just had this in a case in New York last week. They assumed our executory contract, and they had to pay my client $4.8 million of pre-petition debt, because if you assume an executory contract in bankruptcy, you have to cure the pre-petition debt. So it's a way to get paid. So the idea is converting a normal PO invoice, which is not an executory contract, into an executory contract may be a way to make a sale to a troubled company. Preference indemnification. Okay, I've got to give you a warning, disclaimer, and everything else. This is solely the idea of your speaker. I've never seen it anywhere else, and I don't know if it works, but I've tried it and I like it. So you're sitting down with your troubled customer, and you say, I got to have a guarantee, and they say, hell no. And that happens a lot. And you say, well, you're telling me you're not in that big of financial trouble. I disagree. So why don't you guarantee? I'm not guaranteeing. But you're not going to file bankruptcy. Absolutely not, for all these reasons. You know, you've got nothing to worry about. Well, how about, if you won't give me a guarantee, how about this? You indemnify me individually if I end up having to pay money in a settlement or trial of a preferential transfer. You know, I hate those doggone things. And he looks at you cross-eyed because he has no clue what you're talking about, but you explain, listen, you say you're not in financial trouble, that I'm just a worrywart, so fine, put your money where your mouth is. If you are in financial trouble, A, and B, you do file bankruptcy, and C, I get sued on a preference, hate those things, and D, I have to pay money because I sold you during 90 days. If all four of those conjunctive elements, A through D, happen, then you pay me whatever I had to pay for a preference indemnity. It's a lot easier to swallow than a guarantee. Another thing in a troubled company, I like to get solvency representations. I love to get these. And oftentimes customers love to give them. What does a solvency representation give you? If you get sued on a preference, the trustee or committee or plan agent, whoever the plaintiff is, has a presumption that your customer's insolvent 9 days prior to bankruptcy. Well, if you have a solvency representation, you burst that presumption. And let me tell you, that's a big deal. I had a case where we burst the solvency presumption, and we had a 2-week trial just on whether they're insolvent. You see, the standard for whether a debtor is insolvent or not is assets at fair value, less liabilities at fair value. So in order for that trustee to win his preference against you, he's got to hire all these experts to value inventory, receivables, fair value of all his assets and liabilities. And let me tell you, if you have that representation, that trustee wants to settle with you, because otherwise I'm going out and talking to the 10 largest preference defendants, and I'm saying, hey, let's form a group, hire a single expert, and they want to get rid of you. Okay, and representation, you'll agree to make us a critical vendor. Again, that's solely a idea of your speaker. I don't think it's enforceable, so it's probably not a great idea. The good news is we're done. Honest, the computer just went down, or I'd have a check out to you today. I handle the receivables of my firm, so I certainly understand your situation. Well, it's a pleasure to speak with you. I certainly appreciate the foundation for having me. And with that, I've left a little bit of time for questions.
All right, great. Thank you, Joe. So if anyone does have any questions, we have a few in the queue already, but if you do have any, feel free to type those into the question or chat function on your side panel, and I will pose them to Joe. With that said, the first question is, if PMSI is limited to inventory, how do I prevent my customer from selling out my collateral?
Great question. You have to act quickly, because every single day your collateral value is going down by their sales. So outside of bankruptcy, if you're trying to foreclose on your PMSI, you have to go take possession of the collateral. If they won't let you take possession, then you have to go into court and get either a temporary restraining order to restrain them from selling, or a writ of sequestration, but you have to act fast. In bankruptcy, you have to go in immediately and ask for adequate protection, because again, they're selling this out every day, and you're losing your collateral. So the good news is, on a PMSI, you get to jump over the bank, but you have to act diligently and quickly and protect your rights.
All right, great. While we're waiting for some more questions, I did just want to remind everyone that we do have the brief survey that will pop up as you exit the webinar. It really only takes about 20 or 30 seconds to fill out, but we get a lot of invaluable information from it. So a couple more questions that are coming in here are why...
And just remember when you're filling out your survey, I'm the one that brought you the Seinfeld clip. You don't get that anywhere else.
Absolutely. All right, the next question we have here is, why consider mediation if it is not binding? What good is it?
Now, interesting. I've seen situations where we put mediation in a client contract, and what it does is it forces everyone to forget about, immediately doing a lawsuit, and it forces you to come together with an individual party, an independent third party, and try to work through your dispute before you file a lawsuit, before you spend a ton of money, and it prevents people from just running to the courthouse. So if you think litigation is not always the best way to have your grievances addressed, you think it's expensive, it takes a long time, et cetera, and your goal is to get from A to B quickly and cheaply, then forcing both sides to come to a mediation with an independent person saying to your customer, here's why they're going to kick your butt, and saying to you, here's some weaknesses in your case. Sometimes you can get things resolved, get from A to B quickly and much more cost effectively. So you can put in a contract, both sides agree before they file a lawsuit, they'll mediate any disputes. It's not very common, but it's just something to consider.
All right, great. The next question is, what are the steps for obtaining solvency representation?
As part of an interesting question, but A solvency representation can be as simple as an email that says, we're definitely solvent, we're doing well financially, we have no problems. It can be as simple as that. So depending on your customer and your relation with your customer, you can say, listen, A, you didn't give me your financial statements like I asked because you don't give them, so I want you to confirm that you're solvent. Or B, I got your financial statements, I'm a little bit confused and they're a little old. It says you have a net worth of $6 million. Would you confirm that's still accurate, that you do have a net worth that's positive? There's no magic to what the solvency representation is. It's just what the case law says, something to burst the presumption of insolvency, and something that you can legitimately say, I got this, I relied on this to make my credit decision. So there's no special form or substance, but it has some kind of representation. Now let's say you're having a conversation with your customer, and you ask them, are you solvent? You're telling me you're financially viable and solvent? Yes. Well, then I'm going to write you an email that says that. I want you to confirm it. Fine. This will confirm our conversation of an hour ago. You confirmed for me that you're financially viable and solvent. If this is true, please confirm. Confirm. You have it.
All right, Joe, we have another question here. The question is, in regards to bailment situations, can you outline the potential risk if security interest is not perfected?
Okay. I'm gonna get there. The consignment, where your goods are in the possession of the debtor or customer, if your security interest is not properly perfected, you lose it. You become unsecured. Same with PMSI. A bailment, by definition, you're putting the goods in the hands, in possession of an independent third party, not the customer. So going back to a bank monitoring their collateral, looking at the borrowing base, advancing so much off inventory, your goods are not in the debtor's / customer's inventory. They're in an independent third-party warehouse. So there is not a perfection, a UCC perfection of security interest. Now, once you sell, deliver from your third-party warehouse to the customer, you have no security interest. But you're trying to limit, you're only selling the customer what he actually needs, and you're supplying it to an independent third-party warehouse that is not controlled by the debtor. So it isn't a perfection issue. It is a bailment, which is independent of that.
All right. I'm not seeing any more questions here, so I think with that we will take this time to close the webinar. I'd like to thank everyone for taking the time out of their day today to join us, and I'd also like to thank Joe for taking his time out of the day to present to the Federation of Credit. So with that, we're going to shut down, and I hope everyone has a great rest of their day.
Thank you very much.